Welcome to this edition of IBFD's Tax Takes, News and Views, bringing you the week's tax news in a nutshell. I'm Stuart Gibson, IBFD's Chief Editor, Global News in Washington, D.C. With me for our Beyond the News interview is Barry Larking, Special Counsel at IBFD in Amsterdam. On today's show, the BEPS Inclusive Framework meeting ends with a call to get her done. With so many countries moving forward with their own digital levies, will consensus at the OECD, should it arrive, still signal an end to unilateral measures? And bad news for tax delinquents in Europe and the US, but blacklists may not be the reason. These and more, including Barry Larking's interview with Blaise Marin, head of tax at the London office of Jones Day, coming up on IBFD's Tax Takes. First, we turn to the top news of the past week, as reported in IBFD's Tax News Service. The OECD wrapped up its two-day meeting of the BEPS Inclusive Framework last week, the final meeting of Secretary General Angel Gurria's tenure. While Mr. Gurria and his colleagues at the OECD encouraged the 138 Inclusive Framework members to, in the words of a well-known American comedian, get her done, success seemed far from assured. As Pascal Saint-Amans shared with us on this show last fall, the political issues remain the most challenging to tackle, and those challenges were on full display at last week's meeting as nations from Africa to the Caribbean complained that in the rush to reallocate taxing rights, their taxing rights were being left behind. There is still time to address these and other major issues, but in a process that will create winners and losers, it's hard to imagine the potential losers agreeing to give up badly needed revenue, especially in the middle of a pandemic. As if to anticipate the chaos from unilateral action that OECD officials predict, digital service taxes continue to sprout like wildflowers in the spring, or weeds in the summer. Italy is the latest country to publish its DST return forms and establish a filing deadline for the end of March, which had extended to the end of April this year because of the pandemic. This raises an important question. If the OECD gets its wish and 138 countries agree to reform the international tax system, will DSTs really go away, or will they stick around like unwelcome house guests? In the never-ending battle against tax avoidance, governments have deployed all kinds of weapons, from publishing the names of tax cheats, so-called naming and shaming, to depriving companies of tax benefits that would otherwise be available to them, and publishing blacklists of tax havens. This week's news teaches us what works and what may not, and you may be surprised about what doesn't work. Hungary has chosen the naming and shaming route, publishing on a special tax portal the names and addresses of major tax evaders who are in arrears for more than 180 days for more than 10 million Hungarian forints, about $38,000. Well, that country scored a major victory last week when the European Court of Human Rights ruled that its naming and shaming practice did not violate the Convention for the Protection of Human Rights. The court noted that publishing the list was an appropriate measure to protect the country's economic well-being and the rights of others. Perhaps this will encourage more European nations to follow suit. The U.S. does not allow foreign companies that fail to file required tax returns to claim deductions and credits otherwise allowable in the tax code. But what if the company files late? The IRS recently persuaded the tax court that there is such a thing as too late. The court ruled that once the IRS has prepared what is called a substitute for return, the foreign corporation is out of luck. In other words, you snooze, you lose. Many people assume that naming and shaming entire countries that do not play by the rules is enough to discourage those who would avoid or evade their tax obligations from locating or doing business in those countries. But members of the European Parliament question whether the EU's method for drawing up its blacklist of non-cooperative jurisdictions is actually working. They note that some countries make only symbolic tweaks to their systems to get off the list, while other countries that do not tax corporate profits or impose a 0% rate do not even make the list. To address the confusing and ineffective process now in place, the European Parliament voted overwhelmingly to design a new system to be formalized by the end of this year that is more transparent, consistent, and impartial. We will see. Turning to other news. As we continue to report, countries are taking wildly different approaches to the pandemic, with some offering new benefits or extending existing benefits, and others removing or delaying them. Uruguay has just extended from 5 years to 10 its regime that allows inward expatriates to take advantage of a special tax regime designed for non-resident individuals. And in response to the pandemic, the OECD has revised its guidance on the application of treaty provisions concerning the creation of permanent establishments and changes in residence, among other things. On the other side of the ledger, Argentina giveth and Argentina taketh away. That country will not tax remote employees on reimbursement they receive for the extra cost of teleworking. At the same time, it considers postponing a scheduled cut in its corporate tax rates. And Namibia has voted to repeal tax incentives for export processing zones, though wisely most of the repeal will not take effect until 2026. And finally, Rwanda has found a new and creative way to encourage high-end tourism and foreign investment. It has capped the import tax on expensive cars. From now on, car enthusiasts can bring their million-dollar Ferrari into Rwanda for the same price as a $60,000 BMW. Woohoo! Now we go beyond the news for Barry Larking's interview with Blaise Marin at Jones Day in London. Barry.
Thank you, Stuart, for your informative news report. I'm Barry Larking, Special Counsel at IBFD, and I'm delighted to have with me today Blaise Marin, who's Head of Tax at Jones Day in London, and for many years steered their European tax practice. He's therefore the ideal person to give us the big picture on what's changed and what's not changed in the post-Brexit tax world. The UK officially left the European on 31st of December last year. Blaise, what does that mean generally for all the EU-inspired tax legislation that the UK had to implement?
The UK decided pretty early on after the referendum that it wouldn't seek to scrap every rule on the rule book that came out of the EU. So instead, its approach has been to enshrine into UK law everything that was on the statute book in March 19. And then they will repeal on a case-by-case basis any EU legislation that they want to no longer apply to the UK. In addition, the UK has been busy passing various acts to prepare itself for a Brexit. In particular, for example, it's passed a trade bill which creates a domestic VAT system, but there have been many other pieces of legislation that the UK has passed. So the answer to your question, I think, is that nothing changes dramatically overnight, apart perhaps from two sort of legal points. The first one is EU law is no longer supreme in the UK. UK law is supreme in the UK. And the Court of Justice of the European Union has lost its jurisdiction over the UK. So,
right, and they were two of the big Brexit political issues, weren't they? I mean, that's what the public, in a sense, was voting for.
Yes, absolutely. And that's what the UK always said that it was prioritising in the negotiation, which was its sovereignty over its own laws and sort of take back control mantra.
Yeah. So now, when Brexit actually finally came, well, before it came, everybody was concerned about the hard Brexit and what that would mean for tariffs in terms of trade between the UK and the EU. Now, now we don't have a hard Brexit. We've got the Trade and Cooperation Agreement, free trade agreement. That doom scenario has gone away. That makes it slightly difficult to understand, I think, for many people, why there is so much discussion still going on about VAT and customs duties. Can you enlighten us?
Yes. So the FTA has a limited reach. It provides that for goods, but only goods, not services, there will be free, tariff-free trade between the UK and the EU. And that's not as simple as it sounds, because of course, what you need to do in order to decide whether you benefit from this tariff-free trade is whether the goods come from the UK or the EU, or whether they actually come from a third country. So in order to implement the provisions of the FTA, there has to be quite a bit of infrastructure that didn't exist during the time when the UK was a member of the EU, because that infrastructure was embodied in the single market.
So it wasn't necessary.
It wasn't necessary, and checks, customs checks had been automated. People knew how to deal with it. So what we're seeing at the moment is that although trade is supposed to be tariff-free, the checks that are necessary to ensure that those provisions are not abused are causing disruptions in supply chains.
Right, so it's not so much the cost of extra new customs duties, but the paperwork that's needed to ensure that those exemptions effectively apply. What about VAT?
Well, VAT, the UK was never going to abandon VAT, although VAT was introduced in UK law as a result of the membership of the European Union. But VAT makes too much money for the UK government to abandon it. So between the referendum and 31st December 2020, the UK has busily been creating a UK-only system of VAT. So from now on, the EU will just be any other third country as far as the UK is concerned. And the VAT system that applied before Brexit will apply, simply with the caveat that the EU is a third country and not a privileged partner.
Right. So again, extra complications, compliance, paperwork, in order to get the VAT rules applied in the new situation.
Yes, absolutely. And there are going to be some knock-on effects for UK traders. We've already seen, for example, that people who do distance selling from the UK, that is a UK supplier selling goods into the EU, may have to register for VAT in those EU member states when they didn't need to do so before.
Right. Okay. Northern Ireland. Now, I'm not going to ask you to go into all the historic and political background, but can you kind of give a brief indication as to what the problem was and how it's been solved from a tax perspective?
Well, the problem stemmed from the long and complicated history of Northern Ireland, but in particular, as part of the Good Friday Agreements, which allowed for peace in Northern Ireland, the parties had committed to effectively dismantling any border infrastructure between Northern Ireland and the Republic in the south. In the context of a deal between the UK and the EU, that was problematic because the EU was insisting that there should be customs check. The UK had decided not to do them. So the solution that was found in the end was a so-called border in the Irish Sea, which is that the Northern Ireland will be more closely aligned with the EU than the rest of the UK. And the customs checks that are necessary for goods coming from the UK to Northern Ireland will be performed when the goods leave mainland UK and go to Northern Ireland. Similarly, when goods are imported into Northern Ireland from third countries, customs checks will only be performed if they're considered to be at risk of importation in the European Union. So it's a solution that allows no hard border, no border infrastructure, no border posts, which was very important for the continuation of the Good Friday Agreement.
Right. So again, it's more of a paperwork compliance issue than actual additional taxation or additional tariffs, because just as before, trade between the UK and Northern Ireland will be tariff-free in principle.
Yes, absolutely. Yeah. And for those purposes, Northern Ireland is like any other part of the United Kingdom.
Yeah. Okay. Now, we're talking about tax, a lot of focus on indirect taxation, but what about direct taxes? What does Brexit mean for them?
Well, what Brexit means for direct tax is that there were a number of directives in the European Union that were relied upon by multinationals. And those directives covered both funds flows out of the UK and into the UK. Mm-hmm. Those directives will automatically or have automatically ceased to apply.
Right, we're talking about withholding taxes there, I think, in particular.
Largely withholding taxes, yes, mm-hmm. That's absolutely right. So, for example, dividends that are now paid by EU member state companies to the UK are potentially at risk of suffering withholding tax. It's necessary for multinationals to have a look at the tax treaties which the UK has negotiated over the years, and the UK tax treaty network is pretty good.
Yeah, because they're still in place, obviously, irrespective of Brexit.
Absolutely. Yeah. Prior to Brexit, they didn't have much application because EU legislation dealt with these problems. But now they're coming back to the fore. Most of the treaties that the UK has negotiated provide for zero withholding out of the UK, but there are some that don't. For example, Italy, where some fund flows to and from Italy will be subject to withholding tax post-Brexit because the treaty doesn't reduce the rate down to zero.
Okay, that's clear. What about tax planning, tax avoidance? I mean, the EU was fairly successful in terms of introducing or getting member states to introduce anti-avoidance and transparency measures. What's their fate after Brexit?
Well, the UK is an early adopter of all those proposals. So, as by way of a reminder, the EU effort was largely based on the BEPS project, which was conducted by the OECD. The UK was an enthusiastic participant in BEPS and adopted the BEPS recommendations sometimes in advance of the EU. So, for example, we had anti-hybrid legislation before that was mandated by the ATAD directives. All of that stays on our statute book. So I wouldn't say that tax planning will be either easier or harder as a result of Brexit. It's different legislation that we just will have to have regard to.
It sounds like they're going to be aligning more towards the OECD rather than the EU rules, at least as time goes by. Would that be a correct?
That's absolutely right. And again, that is part of the sort of reaction to Brexit, which was we want to take back control of our law. So I think, in a sense, we shouldn't expect the UK to follow what the EU does in terms of ATAD and ATAD 2.0 and following on.
Yeah, there's been a lot of talk about the transparency side and the UK sort of moving away from the EU's so-called DAC 6 mandatory disclosure rules on aggressive tax planning. How do you see that as panning out going forward?
Well, that's an interesting one. The UK during the negotiation had committed several times to implementing DAC 6 regardless of Brexit in full. And in fact, it did implement DAC 6 while it was still a member of the EU. But one of the provisions of the FTA between the UK and the EU effectively guts DAC 6 as it applies in the UK. There are only two types of transactions, or transactions exhibiting two types of hallmarks, that we'll have to report going forward.
Right.
I don't think the UK's always said it was enthusiastically supporting tax transparency efforts, things like the Common Reporting Standard, etc., etc. I think it will continue to do so in the near-term future. In the medium term, there may be some divergence between the EU and the UK in these matters.
Yeah, and of course, I mean, there is also always a possibility that the UK will again align itself with the OECD's equivalent rules, if you like, on that. So I guess, you know, we have to watch that as it moves forward. We're getting to the end of our session, but I don't want to finish before dealing with this concern that has been voiced by some commentators, including members of the European Parliament, that the UK may become a tax haven, Singapore on Thames, as it were. What do you think? Is that a realistic possibility?
I think at this point in time, it's not. I think it was raised by the UK and the EU in the course of the negotiation as a sort of stick to hit the other side with. At the moment, there's no indication that the UK is going to become an onshore tax haven. The UK has introduced quite a lot of the anti-avoidance legislation that BEPS mandated. The UK tax rates are relatively low, but having said that, most of Europe's tax rates are relatively low. It may be that over time, the UK decides that it wants to help particular industries or particular sectors in a way that previously it couldn't because of its membership of the European Union. But there's no sign of it becoming an onshore haven now.
Right. Well, I guess that's a watch this space sign. And with that, we come to the end of our brief discussion. And I'd like to thank our guest today, Blaise Marine, Head of Tax at Jones Day in London, for highlighting and clarifying some of the key issues flowing from Brexit. And that wraps up this week's edition of Tax Takes News and Views, the week's news in a nutshell. And from Stuart Gibson and myself, thank you for watching. Here's hoping your week is not too taxing.